Hi, everyone. It's Laurel with Laurel Bias Houses, and today I have the attorney, Brian DeAmicis. Did I say that right?
DeAmicis. The C is a
DeAmicis.
CH.
Oh, it's Greek.
Italian.
Italian, even
Yeah.
better. How
Yeah.
you doing?
I'm all right.
Good. Thanks for joining us. We're here to talk
Sure.
about questions people have about bankruptcy and what it
hmm
can and cannot do for us,
Yeah.
right?
Yep.
You're an attorney at law. You and I have done business together in the past.
hmm
Your job is to help people.
Absolutely.
And so I want to start off with some common questions that people ask me about bankruptcy that, of course, I don't know. I mean, I'm a general contractor. I'm not an attorney. And I
hmm
don't always know the answers to these. So we want to get you to give
All
us
right.
a quick answers here.
Sure.
So first of all, will filing for bankruptcy stop an eviction?
Usually, it depends on what stage the eviction is in,
Mm-hmm.
and if the judgment has already been entered against the tenant, then the answer is no. So you
Ah,
have to file before the judgment is entered.
got it.
And,
So before you go to
and
court.
right. Well, there's a process. Once you're, it, and we're in California. The eviction
Yeah,
starts
let's
with
just
a
assume
complaint.
California. Yeah.
Yeah, the eviction starts with a complaint. All right, and if the tenant wants to fight it, the tenant files an answer to the complaint, and then there's a court hearing. And after the court hearing, or at the court hearing, the judge enters a judgment. So if you want to file for bankruptcy, you have to do it before that court hearing.
Great.
Yeah.
So that's pretty clear.
Yeah.
Will it stop a foreclosure?
It will stop a foreclosure. Yes. And for both stopping foreclosures and stopping the evictions, it will stall it. It will not eliminate it entirely.
Right.
Right.
So
And
how does
so,
that work?
well, what happens is once you file for bankruptcy, an automatic stay is entered. That's an automatic injunction, and it applies against creditors even if they don't know about it. However, in order to protect yourself, to protect the client, the bankruptcy lawyer should always notify the landlord's attorney or the foreclosure trustee that the bankruptcy has been filed.
Okay.
That way everything stops. Now, once the bankruptcy has been filed, there's a process for the creditor to go to court for what's called relief from the automatic stay, or a motion to vacate the automatic stay.
Okay.
That process, in the ordinary course of events, will take 6 weeks, sometimes as long as even 90 days, depending on the creditor's schedule. It is possible for the creditor to expedite that, but that requires extra time and effort and good cause on the creditor's part.
Okay. Can the
And
person
so
sell their house if they're in foreclosure and they've done a bankruptcy? Can they sell the house?
the answer is no. And that's because legal title, when you file for bankruptcy, legal title to the house technically passes to the bankruptcy trustee.
Right.
So while the debtor is in bankruptcy, the debtor can't sell the house. That's why bankruptcy is always the last. Bankruptcy is like brain surgery. You don't do it if you have a reasonable alternative, because once you file, the debtor stays in possession of the house, but the debtor can't do anything with it without permission from the bankruptcy court and the bankruptcy trustee. And again, there's a process in that.
Right. It takes a long time. I mean,
yes.
It takes a long time to get permission to sell your house, and it's based on the offer and the percentage of it being
right.
appraised and
really,
stuff.
yes.
Huh?
And remember, when you file for bankruptcy, the bankruptcy trustee has a duty to try to collect the assets for the creditors. So if you want to sell the house, a practical way to look at it is you have to convince the bankruptcy trustee that there's nothing there. Either there's nothing there for the creditors, or that the trustee will be able to get something for creditors without having to do any work. or a
Right.
minimum of work, because the trustees don't want to do a lot of work.
Of course not. Right. So
Yeah.
again, you got to know if you file for bankruptcy, you just can't automatically sell the house
No.
and get the money out.
Nope. No,
Because the
that
money,
freezes.
even the money more than the mortgage, is supposed to go to pay creditors.
That's right. Now, the debt. Look, the borrower does have an exemption in those proceeds, but again, it's not the borrower cannot convey good title. No title insurance will cover a debtor who's in bankruptcy.
Right.
So, in order to sell it, if you're the borrower, you want to make sure you have permission from the court and all that to cover your rear end. If you're the buyer, buying for the borrower, you want to make sure that you're protected and that you can get title insurance. So again, the bankruptcy stalls things, it stops things, but it doesn't make the problem go away. So when I'm talking to people about bankruptcy to stop a foreclosure or an eviction, I say, look, this will stall things for a while, but you, my client, you, the borrower, you, the tenant, you have to have a plan for when this expires, because even if the creditors do nothing, an ordinary bankruptcy case, an ordinary Chapter 7 case, from start to finish will take probably 4 months. All right. So the creditor can just sit back and do nothing for 4 months. And once the bankruptcy discharge is entered, the automatic stay is over and the creditor can proceed to foreclose.
Mm-hmm. So it's
again,
just buying time, but it's making harder,
reducing
your options, right?
Yep. So
okay.
Again, it does have a role. I have done it to protect clients, but if you're the borrower, you have to approach it with caution.
Okay. Now, will bankruptcy discharge or get rid of my student loans?
Ha ha ha! I'm laughing. The answer is no, but yes. And that is because the bankruptcy code says that student loans are only dischargeable if repaying the loans will cause undue hardship to the debtor. All right, now think about it. By definition, the debtor's in bankruptcy, so usually the debtor is in a state of financial hardship. So why this extra burden? And the courts had developed a series of tests or criteria that they look for to determine whether repaying the loan would cause undue hardship. And if you, the borrower, can prove undue hardship, then it's discharged. However, first of all, you have to show that you qualify, that you've met all these criteria that have been laid down by the courts. And one of them, of course, is your how much is the student loan? What is your current income? What is your prospective income? What efforts have you made to repay the debt? What other financial obligations do you have? Child support and things like that. So you have to qualify. And secondly, you, the debtor, must file a specific motion with the bankruptcy court to say, hey, bankruptcy judge, I want you to declare this student loan discharged. And so it's not automatically part of the bankruptcy. You've got to file a special motion, and again, you have to show that you qualify.
Okay.
Yeah, and I've had several conversations. In case people don't know, there's a lot of political activity with student loans. Back in Washington, President Biden has tried to, by executive powers, to discharge some of these student loans. The various creditors the agencies have fought back. That's in the courts right now. It'll probably go up to the Supreme Court. It's intensely political. I say this because if you go back 30 years, student loans were dischargeable.
Yeah.
And so what's happened, again, the whole deal with student loans, it gets very political. I tell everyone, stay tuned.
Cool.
But as of right now, the bankruptcy code hasn't changed, and again, the debtor has to has to qualify.
So I get asked this all the time, Brian. What can I keep if I go through bankruptcy? What can I keep? My house? Can I keep my retirement?
All right. In California, California allows for either Plan A or Plan B. And actually, Plan B is laid out in Section 703.140B of the Code of Civil Procedure. All right. So let's talk about Plan B, and that is for people who really don't own their own home, or where the equity is very low, and by very low, less than 35,000. All right. You can keep one vehicle up to a maximum. You can keep all of your household furnishings, TV sets, that kind of thing. You can keep, there are limits as to the value of jewelry and so forth. You can keep, I talked about the motor vehicle. The pension plans are trickier because for pension plans, you have either what they call private plans or public. Public plans are things like civil service, CalPERS, military pensions, and so forth. Those are exempt. All right. And that's why O.J. Simpson is still getting $60,000 a month or whatever, because the NFL pensions are exempt, because the debtor does not control the pension or the pension payments. For what they call private plans, what I call private plans, those are things like 401ks, SCP, IRAs, and so forth. For those, those plans, the money in those accounts are exempt to the extent necessary for the support of the debtor and the debtor's dependents when the debtor retires. And so here we go with another set of criteria that the courts look for. How old is the debtor? What's the debtor's income? What's the debtor's income likely to be when the debtor retires? You know, how much is in there? How close is the debtor to retirement? What other income does the debtor have? What kind of resources? So it's a very gray area. Right? Yeah. It's a very gray area. Okay. Now, if you flip over to what I call Plan A, that gives you the homestead exemption, and that's usually for people who own their own homes. And California law changed recently, and you're entitled to keep your equity in your home up to a limit. All right, and the limit is based on the median price of homes in your area. All right, and so, for example, it's higher in San Francisco than it would be up in Chico. Yeah. Okay. All right. But basically, the way I look at it is you're probably okay if your equity in your house is less than 600,000. That's equity. That's after your mortgage and so forth.
So you can go bankrupt but keep your house and your mortgage out of it?
That's right. Now, the bankruptcy will stop the mortgage. Technically, what happens with the mortgage is the lender is supposed to stop contacting the debtor. That's part of the automatic stay. All right. So if you file for bankruptcy, you have to be prepared to the debtor and the attorney have to be prepared to deal with the creditor, to deal with the bank, let's say the Bank of America. So to work things out with the bank so the debtor could continue to make mortgage payments so that the creditor can continue to send mortgage statements to the borrower. Because remember, the bankruptcy code says the creditors cannot attempt to collect a debt. And sending out a mortgage statement is an attempt to collect a debt. But you, the borrower, want to make sure that those debts paid despite the bankruptcy. So again, the bankruptcy lawyer will be aware of that and will be ready to work that out as part of the bankruptcy filing.
Okay. So besides wrecking your credit, Does bankruptcy have any other negative or drawbacks?
Oh yeah, yeah. It wrecks your credit, although sometimes it can help your credit, which I can explain. um, it can prevent you from getting a surety bond. If you're in a profession or you have a job that requires that you be bonded, bonding
Like me,
company,
I have a surety bond as a
okay,
contractor. Yeah.
you can check with your bonding company. Would they give you a bond if you file for bankruptcy? All right. And the last time I came up with this, it was in the context of a decedent's estate where the court required the bond of an executor.
Oh, wow.
Yeah, all right. That was a problem.
That's a big problem. Yeah.
Okay. It can affect your ability to get a job. Because a lot of credit, the employers aren't supposed to check. They check.
Well, especially since they're not bondable.
Yeah. Yeah. Well, this is just if you're applying for a job, and I don't know that they do this, but let's say you apply for a job as a manager at a fast food restaurant. They may say, we're not going to give a job to someone who's filed for bankruptcy. Forget about the bond. They just don't want anyone who's filed for bankruptcy.
Yeah.
If you're working for an employer, it can affect your ability to get a promotion. If you are in a job that requires, let's just say, high-level security clearance, the bankruptcy can interfere with your getting the security clearance, and that means you can't do your job, or you can't get the promotion, or you can't get the transfer. So we just discussed a little bit. It makes it difficult for the creditors and the debtors to communicate, because again, the creditors can't be sending out the mortgage statements. So the borrower has to go through the lawyer, which creates levels of difficulty and so forth. So this gets back to what I was talking about earlier, where I say, look, bankruptcy's there, but let's see if there's an alternative.
Right.
Yeah.
So again, because we're over time, but thanks everybody for staying on. It is complicated. You need to get great advice about this. Okay. If you're drowning in debt, the law, both federal and state laws, allow for relief, but you need to get competent professional help here. So Brian, why don't you give us we'll put your number and your email and stuff on our website on the bottom here. Why don't you read it out so everybody can hear it?
Yep. I'm Brian DeAmicis, 916-440-8833, and visit my website at briandeamicis.com. That's
great.
me.
So, hey, thanks, Brian, for being on the show.
Thanks, Laurel.
And thank you, everyone, for listening. I know we went over, but this is one of those topics that has levels that people don't think about, and this is a pretty serious thing. You need to really get good legal advice to do this. Don't try to do this yourself.
Absolutely.
Thanks, everyone, for listening.
Thanks.